Thank you. Okay.
Is there one more?
Excuse me, one more. It's for the, excuse me, unexpired term ending 12/31/26, which would be Judge Contos's term that was just vacated for Judge of the Court of Common Pleas General Division. These were nominated by the parties because it was too late to have, excuse me, too late to have a primary. So they were nominated by the parties as central committee meetings. The candidates are Sarah Thomas Kovoor and Cynthia Westcott Rice. Now, it was brought to my attention by the Tribune of a revised code section 3513.04 and a Supreme Court decision, Brown versus Ashtabula County. I was asked, had I heard, in the past I had heard, I knew you couldn't run for a seat if you had already run for that seat in the primary. You couldn't be a write-in, you couldn't be an independent for the same seat. I had not heard of 3513.04 before, so I got a majority of the board requested an opinion from the prosecutor's office. We got that opinion. You all have it in front of you. An opinion, some clarification, at a question that was asked by one of the board members, a letter from Ms. Kovoor, Attorney Kovoor, and we also have in your packet, is a protest. It seems slightly premature in my eyes because it says it's a protest of the approval of Sarah Thomas Kovoor to appear on the ballot. Nobody's been approved to be, neither candidate has been approved to appear on the ballot as of right this moment. This was forwarded, however, to the Trumbull County Prosecutor's Office to see if it was premature. Of course, this happened all at about after 3 o'clock yesterday, so I have nothing back from, as you can imagine, the prosecutor's office on this matter yet. You've all read the opinions, I'm sure. I think you all had a chance to read Attorney Kovoor's letter this morning. And I don't know that I need to summarize for you unless you want me to. The opinions. I don't, but basically what was thrown out there was that Attorney Kovoor may or may not be eligible to run for this seat due to the fact that she was a candidate in the May primary for appellate court. That was what was alleged, and that's what we sought the opinion on.
Okay, and then that opinion came back from the prosecutor's office from attorneys Danzo and Toth, stating that, well, number one, it's clear that the Trumbull County Board of Elections should not certify Ms. Kovoor's candidacy for Judge Contost's vacant office on November 22nd general election. They further state that any argument to the contrary ignores the plain and clear language of the reference portion of revised code 3513.04. And that was just a quick summary of the
three-page letter, yeah.
And then Arno, you went ahead and followed up with some good questions to the prosecutor in follow-up, and they basically came back and concluded the same thing.
Correct.
That it wouldn't have made a difference if Ms. Kovoor was aware of the vacancy or not, right?
That's their opinion.
Right, that's their opinion. So that was provided by Chief of the Civil Division, William Danzo. And then late last evening, we got a kind of a counterclaim or position by Sarah Thomas Kovoor that, you know, you've had a chance to glance, to read through. And I guess at this time, just as a courtesy, I'd like, if nobody's opposed, I'd offer an opportunity for Ms. Kovoor, just to summarize briefly your position. Go ahead.
Well, it's stated clearly in the letter. There is no sore loser here because I would not have even been aware of the vacancy, like all of you were not aware of the vacancy till the end of July, you know. The case in Brown versus Ashtabula is completely distinguishable from my case. That is a judicial race where a candidate ran and then ran again. Here, this is the Trumbull County GOP Central Committee who is nominating me to be on the ballot in November.
As a candidate?
As a candidate. It's not me filing a petition for 2 seats, whether it's Republican first and then an independent in another race. So it's completely distinguishable. And I believe that the courts would have to use strict scrutiny to violate the rights of the GOP to nominate who they feel would be their best candidate in the fall. And I don't think that this would survive strict scrutiny.
Okay.
It is completely distinguishable. Thank you.
Thank you. So, what we have is opinions and a follow-up opinion from the prosecutor based on this Ohio Revised Code 3513.04. I'm sure the prosecutor's office looked at this and scrutinized it from every perspective, I would imagine. Ms. Kovoor's position sounds like it's that Brown versus Ashtabula simply is not applicable and it's distinguishable, to use her words, in a couple different ways. You know, so there was this statute was from 1997. It was upheld. It went up in front of another Supreme Court in 2014, in which it was upheld. So this has been on the books for a while, and upheld it each time. So I think the statute that we're looking at, I think, is applicable, and there can be an argument made, you know, I think either way. I mean, these statutes are interpretable, right? They're not necessarily black and white. But we have what I feel is a very clear opinion from our legal counsel. Stating that it is clear, stating that any argument to the contrary explains the plain and clear language of the reference portion of the Ohio Revised Code. And then in summary, they say, we believe our opinion is clear and straightforward in its application. And then in the follow-up email, they basically restated the same thing. So we have that. We did actually reach out to the Secretary of State, I believe, that we didn't get an opinion from because it was late. Is that correct, Arno?
I've talked to 2 different people at Secretary of State's legal,
Yeah.
and due to the short time frame, you know, I did not get any written opinion. They also said that depending on which way the vote is, they cannot sit there and try to sway which way we vote. They said they can give us, they had a copy of our prosecutor's agreement, and they did say that they were right, that technically you could not run. There also is, I spent a lot of time on the phone yesterday talking. It's also brought up that some entities feel that this opinion was made for not a one-size-fits-all, but to try to cover as many bases as they could in case something like this would happen to arise in front of boards of election. And they also said that they have other similar cases, one being, I believe, Lorraine City Council, where something like this had happened, because this just isn't judgeships. It's
Right.
across the board for any position. on,
There's a couple exceptions, but for the most part, you're
Yeah.
right, yeah.
yeah, the exceptions are like the Board of Education,
Yeah,
and there's
right.
like two other exceptions, in their opinion. I also see where this seat was not open when the primary occurred. And because the seat was not open when the primary occurred, is that enough of an extenuating circumstance for us to figure, do we validate or not? You know, our job here is to represent our electors in Trumbull County, or goes across county lines, you know, like this one does, or have, you know, other ones have,
Mhm.
like the Court of Appeals or something like that. You know, one size doesn't always fit all, and while the law is saying you cannot run, I do believe that sometimes there are exceptions to the law. Now, I've also had a lot of phone calls from electors, way too much information. You know, they come along and say, well, did you know this, or did you know that? A lot of stuff which did not pertain to this issue. And, you know, sometimes they got a little bit personal, both sides, both ways, not just one, not just the other. They came and said, well, did you know this, did you know that? I said, well, what does that have to do with this issue today? And even though the law is clear, you know, I feel that there are, sometimes one size doesn't fit all.
Okay, okay. And keep in mind too, I mean, the duty of this board is to review the evidence, review the facts, familiarize ourselves with the statute, the revised code, any case law that might pertain, seek legal counsel through through the prosecutor's office, all of which we've done. So now we're at a place where we have a very strong opinion from the prosecutor's office, backed up by a follow-up summary along the same lines. So we're gonna have to just go ahead and we're gonna have to ask for a motion to one way or the other. We'll vote and we'll see how the vote turns out. And I will remind everybody that if there's an appeals process, of course. If somebody is not happy with the way this Board of Elections voted, there is an appeals process that they can pursue. Does somebody want to offer a motion?
Well, first, let me ask, is your thinking to consider Judge Rice's certification separately, or does she not need to be certified?
She needs to be certified.
I think we'll just do that after. We just kind of picked up on this one first.
I think we could do them separately.
Okay, no, I think that's good.
Yes.
I just wanted to make sure we knew what
Yes.
we were doing. I've stated this before, I think the public's interest is best served by having competitive elections. And if I'm in doubt, I'm well aware that I could make a mistake, but if I'm going to make an error, I'm going to err on the side of putting candidates on the ballot and not err by striking candidates from the ballot. So that said, I will make a motion to certify Sarah's candidacy.
We have a motion made by Ron.
I will second that motion. I do have grave concerns as far as what's going on here, but I believe that even though there are opinions and case law, there are extenuating circumstances going one way or the other. And we're kind of like, damned if we do and damned if we don't.
Yeah.
But I will make a motion to certify, and I feel this is an issue which, depending on how the vote goes, it should go to Columbus.
Okay. We have a motion and a second. The discussion.
Would you state the motion?
The motion, we have a motion made by you to certify Sarah Thomas Kovoor to the ballot, right?
Yes.
Okay.
Yeah.
I'm just gonna make a statement, is, you know, we have relied on our prosecutor's office for our legal counsel in the past. They have offered a statement that is clear, not open to argument or interpretation according to them. It applies to this specifically. So those were some of the things that they said that gave me the confidence as a board member to rely on their legal expertise, all the due diligence that they did on case law and statute and revised code, and their familiarity with, you know, along these lines. So I am going to defer to our legal counsel's opinion on this. I think just in general, oh, please.
No, that's it.
Okay. I think in general, you know, this was unfortunate, the way that this whole thing, because everybody in this room agrees with one another that, you know, we believe that, you know, open access to the ballot and competitive elections are part of our democracy and things like that. But, you know, from the very beginning, with, you know, not knowing deadlines and things like that, it's unfortunate that we're here and it was rushed to this point. And we're getting correspondence at 8:30 at night and things like that. And we're supposed to make an informed decision. So, you know, based on all that, I am going to again take the advice of our legal counsel, who we've routinely and consistently done in the past. Anything else?
I just would like to say it saddens me anytime that we have to not allow someone to be on the ballot. But I too agree with you that we look to our prosecutor for a legal opinion, and I think this carries a lot of weight.
Yeah, I mean, first and foremost, our obligation and oath is to uphold Ohio election laws. These are laws, these are statute, these are clear. These have been reviewed by our prosecutor, and their opinion is clear and straightforward and applicable, according to them. And so that's where I'm hedging my bets. It's just clear to me.
I would like to comment.
Go ahead.
I can agree with the prosecutor's office. However, my opinion is that this seat was not open, was not even known to become open. And that would be an exception to this. I do not believe that I could see where state law did not want the sore loser or whatever variation of that. However, this was a new seat. And I look at it, say, like if it were the city of Warren, and the city of Warren had 3 seats open, and they had 5 party candidates run, and 2 of those candidates get defeated, and then after the fact, all of a sudden one of those seats come up, and the party decides that they want to put somebody up on the ballot for that seat, and the only 2 people apply are the people who lost. You could say, well, hey, they're losers. Well, what if they're the only ones who put in for the seat? Then they would be getting it. And I believe that I would like to see an opinion come out of Columbus. I do have grave reservation. You know, some of the phone calls I got yesterday, you know, they, both ways. Sometimes, you know, some of the issues, I do feel that this should go for clarification. But I do have grave reservations over this. There's people who deal with this much more often than we do for 87 other counties. And
The prosecutor's opinion, just for the matter of the record, stated pertaining to your point of the vacancy was not known at the time. We believe the opinion letter that was issued yesterday correctly reflects the present state of the law. The relevant portion of revised code 3513.04 specifically applies to filling a vacancy under section 3513.31 of the revised code at the following general election. And they so state that by including this language, the General Assembly expressed its intent that this statute would apply in cases of vacancies where it is possible that the office would not be open at the time of the primary. So they took that under consideration.
I read that.
Okay. I knew you did, but nobody else did. So thanks. Any other further discussion?
Well, I would just make a comment in the court case that is cited in this matter. The Supreme Court's decision was not unanimous. So there's at least one justice of the Supreme Court who felt that the court had erred in its ruling. Sometimes judges change their mind. Sometimes the voters change judges.
Yeah.
So I think that's noteworthy.
This has been on the books since 1996. It was upheld in 1997. It was upheld in another Supreme Court. So two different Supreme Courts looked at this at two different times and upheld it both times. And today it is the rule of law in that statute, as we see it. Jan, any other further discussion? Do you want to go ahead and take roll call vote, please?
Mark,
No.
Arno,
Yes.
Ron,
Yes.
Diana.
No.
Okay, in the matter of a tie, this will be referred to the Secretary of State for a decision.
Right, you'll both have to write position letters, we'll have a deadline. Each, you two together, not separately, and I don't want 4 letters.
Right.
So, we'll look that all up and refresh our memories with that after the meeting.